Welcome to Third Fridays, the monthly legal talk show from Lois LLC featuring attorney Christian Cison. This is the original forum in which real attorneys discuss workers' compensation issues, share their opinions, and engage in colorful conversations. This show showcases diverse perspectives of attorneys handling workers' comp cases, including case law trends, practical litigation strategies, and hot topics. Here's your host, Christian Cison.
Hi, everybody, and welcome to the May 2022 edition of the Third Fridays podcast. My name is Christian Cison, and today we have a really cool edition because we have two attorneys talking about some recent developments at the Appellate Division, the Court of Appeals, and also the state legislature. And then later in the show, we have two paralegals coming on to talk about a really cool fact pattern where fraud is being discussed. So let's start with attorneys, and I'll go to Addison O'Donnell here as my first guest, mostly because you authored a practice pointer for our firm a couple of weeks ago, and you put an interesting quote in there. So maybe you could introduce guest number two, Addison.
Yes. The quote was, "Focus on what the court did, not necessarily on what the court said." And that quote is attributed to Ian Haberstro.
Welcome to the show, Ian.
Thank you. Good morning, guys.
So we have a lot to talk about, and I think in discussing one thing, something else happened, and then something else happened, and we're like, let's just pull it all together. So the first thing we're going to talk about is an Appellate Division update with Johnson and Liuini. Am I pronouncing that correctly, Addison?
I think that's the best.
That's the best that I can do. Yeah. And then when we started talking about it, Gambardella came out at the Court of Appeals level, and we said, let's just talk about Gambardella, right? And then I had a wonderful client who asked me if I could talk about mental stress cases given an update at the state legislature. So we're going to get into a little bit of that to obligate other people to say, hey, Christian, can you talk about stuff that I want to hear? And I was like, yeah, I thought I do that every month, but sure, I'll do that for you as well. So let's start with Johnson and Liuini. It kind of has to begin with an analysis of Genduso, right? So can you guys give our listeners a brief overview of what Genduso meant?
Sure. So Genduso stands for the fact that a claimant cannot enjoy double recovery of a schedule loss of use member. The claimant needs to deduct what the prior SLU was, the prior schedule, onto the current award that's given. And this was an Appellate Division Third Department case that pretty much made a lot of sense. Not a lot of people thought that there were issues with this. It made sense because theoretically one can't have more than a 100% SLU to the arm, for example, or the leg. And so when you're thinking about Genduso, the first thing that we have to think about is, a claimant can't lose more than an entire arm. So it makes sense that if you have a 40% SLU to the arm awarded in a case, and in your prior case you had a 20% SLU to the arm, you deduct that prior 20% from your 40 to a net of 20% SLU.
Which kind of makes sense because that 100% rating, it's like if it's not chopped off, then you have some function in that arm, and you should never reach that just because you have new accidents and get 20% ratings along the way. So in those types of cases, if we were to have them in litigation, what would we do to make sure that a judge or a claimant's attorney is mindful of that when considering exposure or litigating that issue?
Well, obviously, we always do our ISO search, right, to find out if the claimant does have any prior claims. We ask the law judge also at hearings to do a search for prior claims, and then we do our own investigation to determine whether or not the claimant does have a prior schedule loss of use for the same body parts that are in question in the present case. And then we can also have the claimant fill out OC-110As. We do our own investigation, obviously. And many times if a claimant has been with an employer for many years, we'll actually have, hopefully the employer will have access to prior records to determine, whether or not the claimant does in fact have prior claims with the same employer. Sometimes they don't. But typically we do our own investigation to determine
That's actually funny because Ian works with a client where he's gotten used to saying, please provide us a list of all the prior claim numbers. And it comes out that they have 18 prior claims with the same employer, and settling all of them at once is a hurdle in and of itself. But it's a good practice, right? To make sure that we know the history before we lead to the present, right? So Genduso, straightforward, simple. Then Johnson and Leowini come along. What are those cases about, Addison?
Sure. So these cases went to the Court of Appeals, the highest court in the state of New York, which, the Court of Appeals only reviews one workers' compensation case a year, if that. So at this point, both Johnson and Leowini dealt with a Genduso problem. And the idea was that, of course, in Section 15, in order to receive an SLU award, it needs to be one of the extremities, one of the listed members, right? It says the arm, the leg, the hand. But what about the elbow? What about the shoulder? And Genduso has, bridged this logic. Genduso said, well, the elbow's the arm, the shoulder's the arm. Well, Johnson Leowini essentially, in my opinion, gutted Genduso, because what the court said there was that if there is a compensable injury to the shoulder, which resulted in a subsequent SLU to the arm, and then the claimant has another case, injury to the shoulder, that results in a SLU to the arm, that you don't need to deduct, as you were mandated to in Genduso, for your second shoulder arm SLU. It contemplates subparts. They use the phrase subparts, which, I'm not necessarily a textualist, but if you go through the entirety of Section 15, the word subpart is not there at all. This is purely court interpretation. And so it actually throws a wrench in things, because Genduso from 2018 until now, there's a whole plethora of cases where we've been applying the law, and now all of a sudden the law is changed again.
Right. Genduso was almost a term of art now in workers' comp. You could say it, and most experienced practitioners know what it means. Judges, right? You say Genduso, and you don't have to really explain it. You say it almost like bocce, like people know what that means. American Axle, people know what that means. Genduso became part of our culture, and now it's being, I don't want to say it's reversed, because it's not, right?
Without a question.
Right? Well, because the decision didn't actually say we are reversing Genduso, right?
Well, focus on what the court did, not necessarily what the court said. That's why I believe it's gutted. They may say we're not overruling Genduso, but you don't have to deduct subsequent SLUs from your previous SLUs. That was the whole proposition of Genduso in the first place.
Right. So, Ian, let's put yourself in the shoes of a claimant's attorney for the first time ever.
I love this decision.
Right. I think that was too quick.
Yeah.
I was like, do you not like what you do enough? No. So let's say you have a 15% schedule to the elbow,
yep.
Right? 2 years ago, and you hurt your shoulder, same side. So you then pursue something post Johnson and Leowini to get an additional 20%. What are you telling the claimant? What are you advising the claimant when he or she goes to the doctor, or when he or she is testifying before a law judge to explain that the elbow is different from the shoulder?
Well, on a practical purpose, obviously, I think almost everybody would agree that the elbow is distinct from the shoulder, right? The claimant basically would have to go to their own doctor, indicate that he injured his shoulder as opposed to injuring his elbow, and that the shoulder injury was in no way related to the prior elbow injury. And that would probably come out way before he even went to the doctor, right? He's going to fill out a C3. He's going to say he was lifting something and he felt pain in his shoulder, makes no indication of any injury to the elbow. I think for a law judge's purposes, that's pretty clear cut. The judge is going to say this is a distinct injury to the shoulder. The claimant would be now entitled to a potential SLU in the future for the shoulder, in addition to his prior SLU for the elbow, and he would not have to deduct the prior SLU for the elbow, right? So this is a win-win for the claimant and claimant's attorney.
Right. So you have 50% to the shoulder 3 years ago, and now 50% to the elbow. Award me as if my arm has been chopped off.
Correct.
Right? Amputated. So Addison, take us back to defense now. Ian, as a claimant's attorney for this brief moment, is advising the claimant that way. What are we doing on the defense side to counter that?
I mean, we live and die by the medical. Honestly, we need to put the claimant to proofs. We have to, first of all, figure out if this prior injury was disclosed, because then we can raise a Section 114A defense pursuant to Calderon, another Third Department case that addressed, this Genduso, same site, non-disclosure nexus. Basically, we got to get the best IME we can possibly get. And at the same time, expedited subpoenas, get those ISO claim searches, get those medicals in front of the doctor. Because in order for our doctor to be competent and to comment, that's how we are going to, launch our first attack. And of course, the second attack is cross-examination of the claimant. Because if the claimant didn't disclose even to his own counsel that he had a prior SLU to the same site, well, then we have a Calderon 114A violation.
That's interesting, too. When you say live and die by the medicals, because oftentimes, because we lived in a Genduso world, if you had a shoulder injury and you found out that you had a comp claim for the elbow or even the opposite shoulder, we might not pursue those records because it's not going to give you a Genduso application, right? The left shoulder is not going to give you a Genduso credit for the right shoulder. Mm-hmm. But if the claimant can prove that, the elbow SLU is not going to be credited, right, in a post-Johnson and Leowini world, then maybe I want the subpoenaed records from a claim that might not necessarily be like point A to point B, right? Very obvious. But if they show contralateral range of motion, mm-hmm. then maybe you have a different baseline, right? The things that we still do in our practice today where we look at old baselines to say, okay, your baseline is not 180 degrees. If you came to us with 150, your loss of motion is from 150 and not from 180. Maybe that's another way we can also attack lower SLUs, because if I can't get a credit, then maybe I want more records to show, well, okay, fine, but there's a different way that your loss of use is measured.
Absolutely. And there are gems in medicals, right? The prior case might have an EMG and CV to the upper extremities, which show positive findings to, the peroneal nerve at the elbow, but also the nerve at the shoulder. I mean, that implies that there is some positive finding to the elbow way back when, and vice versa.
That's a great point. Right? If you can find in those medicals that, the elbow and shoulder aren't distinct, right? And you mentioned putting the claimant to his proofs so that the claimant, meets that burden. We can dispute that meeting of the burden voluntarily by finding those records and the connection between the elbow and the shoulder in other medicals. Right. So Johnson and Leowini, yes, great for claimants, right? Because what new law isn't? Well, most of them are. But we have some strategies in place for them. We'll see how the board works it out, because, as Ian says, focus on what the court does and not what the court says, right? We'll see how that plays out. In talking about those two cases, we were led to Gambardella. Now, I really like the approach that you guys have with this case, because you're very I don't want to say... meticulous. I would say meticulous about how this is going to be used. I'm going to take an opposite position because I think it's not as crazy, but I think it's good for a reasoned debate here. So who can give us like an outline about what Gambardella is and how that is different from what prior case law talked about?
So obviously we had the Taher decision that came out and said essentially if a client or
only a couple years old, Taher, right? Not less than 5 for sure.
2020 maybe?
Less than 19? A couple years. So go ahead.
That, I believe that was a case where the claimant had returned to work. He was working as a driver and he had injuries to his neck, back, and also schedulable sites. They went to the court. They wanted to classify the claimant, but he also had SLU awards. The court turned around and said, I believe it was I guess it went to the third department. Yep. And the third department obviously made this decision that the claimant would be entitled to schedule loss of use awards, even though we typically always argued for classification, right? If the claimant had a permanent injury in the systemic area, in addition to having injuries to the schedulable sites, we always argued before Taher that the claimant should be classified and not be entitled to a schedule loss of use award. Well, Taher overturned that and basically said no, if the claimant would not be classified on that date and he would be entitled to a schedule loss of use award, he can collect a schedule loss of use award.
Right.
Then we have the new decision, Gambardella, right? So this comes along and this expounds on it. And it gives it explicit bases for claimants to pursue schedule loss of use awards in the similar circumstances, right? If they have the neck back injuries and they also have injuries to the extremities, then all of a sudden now Gambardella is saying a claimant can voluntarily retire or he can fail to demonstrate labor market attachment at the time of classification in order to pursue a schedule loss of use award, as opposed to being classified. And why do we care about that? Because many times a claimant can be classified at a much lower rate than what his schedule loss of use award would be. So a claimant, when they receive a schedule loss of use award, they receive a lump sum payment, as opposed to getting weekly payments when they're classified, right? So from a carrier's perspective, obviously we don't want to pay out $200,000 all at once when the claimant should really be collecting $500 a week, right? The claimant may go back to work. It's rare, but it does happen. And all of a sudden, a carrier has just lost a huge chunk of change immediately because of this Gambardella decision.
Right. So what is the mindset then of the claimant's attorney, Addison, right? When you see Gambardella, how are you focusing on getting the best possible outcome for the claimant in this case?
Right. And basically, Claimants Counsel has changed their mentality since Taher. Prior to Taher, I just need to underscore this in order to give an answer. Taher, basically prior to that, we picked one or the other. It's either SLU or LWEC. It's either classified or, schedule. And so at this point now, both are layered, right? So now as a Claimants Counsel, I would sit back, relax and say, okay, well, carrier's going to raise a labor market attachment defense, but that only goes as far as an LWEC check. It doesn't go for a schedule loss of use award. After all, there are hundreds, if not thousands, of cases where claimants voluntarily retire, 35 plus years of work, get occupational disease claims established due to repetitive use to the wrists, to the arms, to the legs, and get a large SLU payout because of that. It's essentially a glorified one lump sum retirement fund. So no cynicism there, but basically as a Claimants Counsel, I'm doing the math and saying, are you going to be better off with an SLU award or an LWEC? And unfortunately, am I, as Claimants Counsel, going to be better off bring home a larger check to my firm using the SLU route or the LWEC route?
Right. So you're trying to figure out which one is going to be more valuable to the claimant, which is why I'm going to take, I don't want to say it's the opposite approach, but why I don't think it's such a drastic change is because if in Taher you could receive 2 findings but only 1 award, right? That still applies here, where if a claimant's going to choose to not pursue labor market attachment and then collect his SLU award, right? He can then presumably reattach in the future after he gets his SLU check and then pursue an LWEC award, but it would be credited by the SLU. So that's why I think that it really hasn't changed that much from Taher, this Gambardella decision. I think this Gambardella decision just says, hey, you don't have to be savvy, claimant's attorney and claimant. Here's a way to do it.
Mm-hmm. And it gives them explicit authorization to do it.
So as defense attorneys then, right, if we know that's how the claimants are going to strategize, I mean, we're taking almost the same considerations. We're just talking about less money instead of more, right? So can you describe a context where we want to go for LWEC instead of SLU and then SLU instead of LWEC, given Gambardella?
Well, obviously with SLUs, if both sides doctors give high SLU awards, and let's just say I'm not going to say it's common, but it's reasonable, right? You could have a claimant come in with 20% SLUs to both shoulders, 20% SLUs to both legs, and that's going to move quite a bit of money to the claimant, right? So we obviously want to avoid that. And unfortunately, what happens, our IME also concedes high SLUs based on range of motion deficits. And let's say it's legitimate. Let's say that throughout the course of the case, the claimant has had deficits in range of motion, right? So we're not going to be able to argue fraud. So we would obviously want to avoid these high SLU awards, right? We want to move towards classification, correct? But Gambardella basically is going to give the claimant an out and say, listen, even if he's being paid at a TP rate prior to the classification hearing, he can come up and he can show up at the hearing, say, I'm not attached. I'd like to get my SLU awards, credit my prior payments of whatever. Let's say he was out of work for 1 year and maybe it's...
Well, what about this? Oh, let me just present an alternative theory to that, right? If the SLU awards are that high, what prevents a claimant from saying, no, I want to be attached, I'm attached, but I'm choosing the SLU award. I want to be paid at once, because they have that option, right?
Well, then obviously we would litigate that and we say if you're conceding that you're attached, then you're going to be paid at the classification rate and not at an SLU. You're not entitled to the SLU award, right? Because what does Gambardella say? It says here.
I think that's what we'd be arguing, but I think that a claimant can still pick the SLU award based on Taher and subsequent progeny, right? Like they can choose the award and not necessarily the one that is linked to attachment, which is why I don't think Gambardella really changes things. It just gives a playbook.
It does. I mean, I think that, if this basically would neuter our labor market attachment defense, right?
That's such visual words.
It's true, though. Like carriers have to have defenses, right? We're entitled to raise defenses. Defenses can't just be gutted, right? They can't just be negated on the drop of a hat. So, one way that I think would avoid all of this ambiguity is, which it's, in my universe, this would happen. At the hearing prior to the trial set for permanency, at that point, the claimant would make the election for an SLU or an LWEC determination to be litigated at the subsequent hearing. Then we wouldn't have to go through this rigmarole of, well, what if he chooses this? What if he chooses that? Now, at the same time, right, a good carrier's counsel would be on his or her feet and say, I'm able to make the argument no matter which one of 7 ways the claimant may decide at the hearing. But it gives a little bit more predictability and stability in my universe, right? Because then we can go to a client, then we can negotiate with claimant's counsel, then we can strategize the case. So at the end of the day, yeah, the claimant probably could pick the SLU over the LWEC because it is the claimant's election to do so. And Gambardella essentially galvanizes claimants to make that determination.
Yeah, I think the only situation where they would not be pursuing the SLUs is obviously if the prior payments exceed the SLU award, right. Then they're going to go, for classification or
a low SLU and
exactly.
You have like a high LWEC, right?
Yes.
Like, for example, I have a neck injury and multiple surgeries on it because they failed and now I can't do anything. And then I have this like hand injury also. And because I've been paid mostly because of the neck injury, even temporary disability, the hand schedule is not going to give me a lot of money. So I'm going to say that I can't work ever again, right? And go for the 75% LWEC.
So let's throw this out there, Christian. All right,
Look at how excited he is. I'm ready. So excited for this.
How about this scenario?
Okay.
Claimant goes back to work at reduced earnings, causally related reduced earnings. Obviously, they've demonstrated that it is causally related, gets to the classification hearing, schedule loss of use awards would move a lot of money. We already know the claimant is working at causally related reduced earnings, and he decides to say at the hearing, either one, he says, now I'm back to full earnings, which he probably would have to demonstrate, or that his reduced earnings is no longer causally related to his work injuries. What happens then if he's been being paid at reduced earnings all that entire time, and we were paying him and relying on his representations that they were causally related, but now he's changing his story to try to get an SLU award?
Right. So the permanency awards are credited to each other, right? So if I'm the claimant and I'm at reduced earnings, I always think I'd be the best claimant's attorney, right? Because like you take my defense creativity and put it on the claimant's side, I just steamroll everybody. But I'm working at reduced earnings.
Yep.
I'm not going to say that I'm working at full earnings or concede that they're not causally related. I'm going to say I still have reduced earnings. Give me my SLU check for $100,000 and then restart my reduced earnings after the $100,000 is credited towards the total LWEC award, right? So if I get an LWEC and then that LWEC with my reduced earnings rate would equal gross of $200,000, you pay me the $100,000 upfront, and then when week number X occurs where that would be the 100,000 and 1 penny startup, that's when you start paying me the reduced earnings check to go to the LWEC classification and capped award.
But you conceded to the judge that your reduced earnings was causally related, right? So that means that you have some type of permanent impairment that prevents you from working at full duty, and that's essentially a classification award. And you've already conceded to that, so why would you be entitled to an SLU award?
Because Taher says that I can pick.
I know.
Taher says that I can get two findings. I can get a 50% LWEC and a 40% SLU. And that's why Gambardella doesn't change things for me. I think it just gives our thought process and our creative minds to a claimant's attorney who's not thinking that way. Mm-hmm. A claimant's attorney is just and hey, I'm not putting all of them down. There are definitely some very talented claimants attorneys. I think the vast majority of them probably look at, let's do this math problem and that math problem and say, whichever one is better for you, you take it. Mm-hmm. But in that scenario, which is, I have to say, like, I don't know if that scenario has played out that often because pre-Gambardella and pre-Taher, because you'd have to take yourself to a place creative-wise where you're going to make that argument. And now that Gambardella says you can do this way, I think more people are going to try it.
So the language here, right, it says, we recognize that a claimant could elect to voluntarily retire or otherwise fail to demonstrate labor market attachment at the time of classification and therefore create a condition necessary to receive an SLU award, right? So if you were receiving reduced earnings...
Right, they're saying he can't get an LWEC award, so he has to get SLU. But when they say, going to your textualist thing, when it says, we recognize the concept or the hypothetical of that happening, means that it could happen before this case. So I really think that you're going to have more situations like this because of Gambardella.
Oh, they're going to, yeah.
But not because Gambardella is creating a new opportunity. It's just telling you something that you might not have thought about.
Right. Well, if I may, there's also a very interesting fact in Gambardella. The board at the Third Department is a party and is represented by the Attorney General for the State of New York, the Honorable Letitia James. The board is arguing what a carrier would theoretically argue. Saying that no, this is the wrong application of the law. And I find this very intriguing because it basically illuminates as to what the board is thinking. At the last board meeting, the board agreed to file a motion for reconsideration and for permission to leave to the Court of Appeals. I think that the Workers' Comp Board is going to take it as far as it can in order to get a result that it wants. Now, my question is, why does the board want to do that?
So I think it's more out of resources than law, right? Mm-hmm. Because with this, like, playbook opening, mm-hmm. there is going to be so much litigation when this thing happens, when you have schedule plus non-schedule.
Yeah.
And, like, you're talking about predicting what the other side's going to do, and then a judge is going to have to, instead of saying, well, it's 40% versus 50%. I just got to read a couple things and I'm good, right? You can't do that anymore when you're presented with a Gambardella situation, because you have to decide so many different issues. You have to decide labor market attachment, you have to decide causally related reduced earnings, you have to decide classification, and you have to decide SLU. Whereas without a playbook saying that this could happen, then most people are going to pursue one easy route to resolve or to litigate adjudication, and then you have your deal. So that's why I think the board's doing it.
Yeah, it's all surmised, but I think ultimately that the board doesn't want unhappy claimants. I think claimants might look at Gambardella and, assuming sophisticated claimants, right? They might look at Gambardella and say, oh my God, my counsel told me to do X, Y, and Z, and I could have done A, B, and C instead and have gotten a bigger check. And I think that the board doesn't want to reopen cases that have already been gone. The board doesn't want to upset the governor. The board doesn't want to upset the people of the state of New York. So at the same time, why, if the board is claimant friendly, then the board should with open arms accept this.
Right.
But they're not. It's not. The board is essentially fighting back and saying, no, this whole virtual banking, right? This was also discussed in the Arias versus NYCTA case at the Third Department, which happened after Taher, but before Gambardella. There's this issue with virtual banking, right? A claimant can pick and choose what he or she wants to get at the end of the day and bank non-schedule awards after getting an SLU. But as you've aptly noted, Christian, in the Taher footnote and in Gambardella, right, this is contemplated. Just deduct whatever that non-schedule award was to your SLU, and that's what the claimant would be entitled to, which would usually be, nothing. It would be an overpayment, essentially.
Honestly, though, the board, after a bunch of these decisions come through, I think at the workers' comp hearing level, this is going to make things almost more efficient, right? Because I think there's going to be less pushback from a claimant's attorney. They're going to be like, no, I just give me my scheduled loss use awards. And
bigger counselor check.
Right. So I mean, it'll be litigation from our perspective, but from a claimant's perspective, I think this makes it very easy and efficient for them, right? They just get to go.
That I agree with. Yeah. Right. Like when you give away the recipe for how the sausage is made, there going to be requests for more sausage, right? Mm-hmm. So it's certainly something to look at. I think that we can at least reasonably agree that it's going to inspire some change at the board level, because there's going to be more ideas being set forth about how to do this and how to apply it best. But let's move on to some statutory construction, right? So our third topic of the day was actually brought about by a client of ours who asked a question to me about a pending bill. And the bill had to do with mental stress claims. Because before this bill, you had to be a first responder to argue that you don't have to prove that your mental stress claim puts you in a position that was not similarly situated with another person in your space. So you figure, your police officer, your firefighter, your emergency responding employees, they have such a heightened level of stress in their job that they shouldn't have to prove that I am more stressful than my cop partner buddy next to me, right? If you have mental stress, you can just prove it in the normal way a compensation claim is put forth. This bill is designed to say we're not making a distinction between whether you're a first responder or not. Any worker can do it. Now, I have some thoughts about it, but I'd like to see what you guys think. Obviously, it's another situation where it could benefit claimants, right? But explain maybe what you see with this, guys.
So just on looking at it on its face, this could potentially, and let's just point out, obviously, this is not past the assembly. So this is not law.
Right.
We're not under the gun yet. But this would open up the floodgates to ridiculous claims. This could basically turn any office worker, any employee saying that I have suffered some type of mental stress with my boss, with my coworkers. They can go and file a claim, and honestly,
downstream. I could say the person I'm supervising has caused me stress. Mm-hmm. Right? They're not doing their work on time.
So this would obviously create a ridiculous amount of claims. As soon as this becomes common knowledge, and obviously coworkers talk to one another, this could quickly spread and would become a very big problem, especially from a carrier's perspective, because one, we all know that trying to disprove stress claims, any type of psych claim is very difficult, right? There's no objective MRI test to confirm an actual injury. It is very subjective, and the likelihood would be that a claimant would be able to continue to receive benefits with very minimal medical proof of same, right? Like, we all know that treating psych doctors will gladly say this claimant has an ongoing psych disability. And what are they going to do? They're going to keep treating, they're going to keep billing, they're going to keep turning out the reports that say 100% disabled from, somebody being yelled at work, and the claimant can't go back to work. That's a big problem, is it not?
Yeah.
I want to explain what the whole apparatus looks like in terms of Section 10.3. In order to understand...
You said you're not a textualist, but I really like the statutory background here. It's true.
Well, in order to understand what 10.3 is, one has to understand what Section 2.7 is. Section 2, subsection 7 defines what a workers' compensation injury is, but it's also the definition of what can't be established, right? So it says that a stress injury cannot be established under Section 2.7 unless one can prove that the stress is greater than the normal stress enjoyed at work. So that has been our friend, right? We can, whenever people would come into court and say, hey, judge, this is a mental stress injury, this is ANCR anxiety, we can say no. We have an employer witness. What the anxiety allegation pertains to this event has nothing to do with, and nothing to do with the claimant's purporting. It's the ordinary course of the day, right? So then you won't get ridiculous claims like, oh, I'm the supervisor and I'm really stressed out by managing my subordinates. So the idea was that Section 10.3 provided an exception to this Section 2.7 rule. And the exception was this: police, firefighters, I believe, is it ambulance workers? It's all kinds of first responders. They can't come to court and say, I have an anxiety claim, and the board just says, no, we can't do it because of Section 2.7. This is the exception to the rule. The idea is that if there's an emergency, right? If a responder or a cop is in the line of fire and sees his or her partner get shot, right? And now is alleging PTSD or anxiety, the board can't disallow the claim outright. The board will have to go through the 10.3 exception. So in terms of lingo, it's known as the 10.3 exception. I am appalled at again, the legislature is gutting 10.3, neutering 10.3, only because, right, it's deleting the whole idea of a work-related emergency. It's saying it's anybody at any work with any extraordinary stress, so long as that can be proven. And, it saddens me because I feel like police officers, first responders, they sort of deserve this exception based on their line of work. And now they're saying that anybody who's afraid of anything in any way whatsoever can get a mental stress injury. So this is why I'm sort of shaken from the appellate perspective.
It's actually kind of putting that together, right? You talk about how easy it is for these psych doctors to put forth medicals that can't be disproven by objective evidence, right? There's no MRIs. I was actually on a client call with other panel firms a few months ago, and I won't cite this gentleman for it, but it's such a funny joke. I know it may not seem 2022 politically correct, but he termed these psych disabilities as like soft tissue of the mind, right? God. Because you can't objectively disprove like a pain threshold of a claimant, similar to how you can't disprove, that someone is stressed, right? And so the typical workaround for claimants attorneys would be to say, well, you have your orthopedic injury, just go to see Dr. Rombaum in his office, right? See what they have to say.
I thought you said we weren't saying names.
Well, so I mean, doctors, fine.
Yeah.
So this person, right, is then going to have a consequential major depressive disorder, right? Because like the way that office operates, my problem with that is that they don't have reports that say he is not having mental stress, not having anxiety, not having major depressive disorder. It's always something. And it's a very, very difficult burden for us to overcome once they've satisfied their minimal burden, right? But here's what I'm thinking about, right? You have an abject mental stress claim, right? Direct result of something that happened, right? It's not consequential. It's a direct mental stress claim. It's going to be easier for employers and carriers to do the whole deny pending investigation route, right? Because a lot of judges, when cases are denied for orthopedic and neurological injuries, right, they go to us and they say, this looks pretty clear, Mr. Haberstro. Why are you denying it? I'm considering a frivolous controversy penalty. I don't think you can do that with this because it's something that an employer can't see, right?
Right.
Most of the time, you don't see an employee having the mental stress that's manifested later on down the road, or they're going to have to report it in a way where you can't even really investigate it, right? That's just what it is. So I think there's going to be a lot more claims that are denied pending investigation. And my thought process is here, and obviously case by case, it's a full out investigation into this person's life, right? You talk about ISO reports. I mean, you might not have a lot of hits on those, but medical canvas, right? Talking about social media, like if you file a mental stress claim, your social media is going to be checked. Because what they're going to do is present themselves in the worst possible light to a psych doctor and not present their Facebook or Instagram posts where they're just like yamming it up at their friend's birthday party, right? So I think it's more of like, it's like attacking it from all angles, right? We're not waiting to see if the claimant comes back to work. I think it could be because it's so speculative almost from a person saying I have mental stress that we can't just simply hope that they stop anymore, right? A lot of times we do that for cost preservation, right? Bring the person back to work. We're not fighting them on every case, but there's so much of a propensity here to just take this and run. And like you said, Addison, a police officer, a firefighter, they sign up for this stress, and before the 10-3 exception, it was, well, you signed up for it, right? Assumption of the risk. And now you're mentioning, well, they kind of deserve it, right? Because their everyday stress is different from our everyday stress. Their stress every day has to deal with life and death. Ours is not life and death. Right. So there should be the distinction between the emergency first responders and the regular, I don't want to say regular, but the other average employee, right? Mm-hmm. Do you think that defense strategy could work?
Definitely. What I would think from a judge's perspective will probably be how credible our IME is compared to the treating doctor, right? Because we're going to have a lot of circumstances where a claimant is alleging that they got yelled at and they develop stress. So then we're going to have to make sure that we have the proper IME who's going to actually go through the criteria for whatever PFME condition is found, right? Anxiety, PTSD, major depressive disorder. And we want them to go through all the criteria and really do a thorough analysis, which I feel like many IMEs do not always do. They will do their clinical interview if it goes to a psychiatrist. A psychologist usually does use a battery of tests, which maybe we want to push, IMEs that are psychologists as opposed to psychiatrists in certain circumstances, just so that they have to go through all the criteria to prove or disprove that this claimant actually has the condition that they've been diagnosed with by the treating doctor. And if we have a credible IME, then it's really going to come down to the judge will be like, well, this sounds unreasonable to me. I can't see you actually having an ongoing psych condition as a result of being yelled at. I'm going to find the carrier's IME more credible. I'm going to disallow the case. Would that?
Yeah, I mean, I
the
can
most
see that. I could see
straightforward-
that. Yeah, I could see that. I could see that happening. You'd have to really plan it out that way. But you're right. I don't think even with an investigation into all these different facets of a claimant's life, you're not getting anywhere without that good IME who's going to dispute it, right? You really do need that IME. I mean, I know sometimes we talk about cases where you don't want the IME. This seems like we really need a medical doctor saying you either don't have it or what you have is not related to what happened.
Yes.
And this is one of the good reasons why we're now masters of the PTSD MTGs.
I was just going to bring that. That was great.
The new PTSD MTGs directly refer to, cite, incorporate the DSM-5. And so, I my cynicism is showing again. I hate PTSD cases because PTSD is reserved for
true stress,
the truest and highest stress and anxiety. There are veterans who come home and they can't even enjoy everyday life with their families because of PTSD. And so whenever I see a case and it's like, oh, a box dropped and it was a loud boom and now I have PTSD, it like irks me because is it truly PTSD or is it just retaliation against the employer for some reason? Or is it a claimant's counsel saying, oh, we'll just allege it? And now that doctors, of course, IMEs and treating doctors, but now that doctors have to be aware of the DSM-5, right? They have to be aware of PTSD, and PTSD has several axes. I mean, I think there's 4 or 5, maybe 6 different boxes to check in order for a diagnosis for PTSD.
And usually, it's the very first. I call it whenever I do my cross exam, the threshold criteria. Right? Was there a serious injury or threat of bodily harm? This is actually why I asked many times at depositions: was there any was there any weapon involved, right? Was there any actual threat of possible death, or were there any injuries suffered that could have caused death? And many times the treating doctors they'll concede. There was, no joke, I've had 2 claims. I had one claim for PTSD as a result of slipping and falling in ketchup or mustard. It got established. Not here. Don't worry. And I had another claim for PTSD that got disallowed, but it was from folding linens.
What?
I am not kidding.
Well, see, that being disallowed gives us some hope.
Yeah, I know.
Right? It's like there are ways that maybe the judge is actually looking at it like you, Addison, right? Like, wait, this is a diagnosis for veterans that come back from war, from our first responders, and you're going to say that you're folding linens and you have PTSD? You're out. I'm sorry, you're out.
It's ridiculous. You know how you said earlier that you wish that you were a claimant's counsel for a day?
I didn't say I wish. I said I'd be great.
I said it'd be great. You could create as much chaos as possible. I wish I were a claimant for a day. I would be creating as much. I would allege all kinds of stuff.
You with the theatrics of it. This is bad. I actually would, because you would be the claimant that I'll be on the stand. I'd be like, like I can't. My tricks. No, he's gonna know my tricks, and I have to figure out a different way to out trick you. Because you play the theatrics
surveillance
of the
me. Surveillance me. I'll be walking down the street throwing like my cane in the back of my car. It'll be fine. No, but it just shows how ridiculous this 10-3 exception amendment is. So to bring it back to the legislature, at this point, Ian noted that it's going to the Assembly. The Assembly, it's in committee. It's in the Labor Committee. So everyone's fighting over the language. If the Labor Committee adopts the language as is that the Senate adopted, then the law is passed. If, of course, the committee has different ideas as to the language and revises it, it gets sent back to the Senate, and then we're from square one again. Once the Assembly votes yay on it, it becomes law as a matter of fact, rather as a matter of law itself. Governor Hochul can sign it ceremonially, but for all intents and purposes, it's just waiting to be applied. And then at that point, then we're in hot water. Then we got to figure out how are we going to litigate this. And I think we have good ways to do it. I think we have good tools.
So yay or nay, Ian? Does this version of the bill get signed into law? What do you think?
Nay.
Addison?
Nay.
I'm also going with nay.
Nay.
I think that this is a very, very scary thing, and that it plays into it. I think there's going to be some type of revision at the very least, but I'm confident actually in our legislature that this will not be the current version, because there's going to be stakeholders on the side of the nay vote that we might actually fight in other arenas, right? Because implementation of this law or this bill as it is currently constructed will wreak havoc on the system. So, Addison, Ian, thank you for coming onto the show. It's been one of our longest attorney discussions ever on the show. But we'll be right back with Pri Rana and Krista Karamanis with the Paralegal Minute, where they're going to talk about a fraud case involving a claimant who golfs so often that makes me feel even more bad about my skills. So we'll be right back. Okay, and we're back with the second edition of the Paralegal Minute, because it's been a minute. And I have two new guests on the show, Pri Rana and Krista Karamanis. Welcome, guys. Are you happy to be here?
Yes. Yeah.
Oh, so forceful. Definitely not a practiced yes. We were talking about this right before we came on, and playing back whatever we record, and I said, "Oh, I hate listening to my own voice." What did you say?
Are you sure about that?
I actually thought that was real. I was like, no, I'm really not sure.
Yeah.
I didn't realize you were just clowning me because
you love to talk.
I love to talk. I love myself and I love to talk. If you don't love yourself, who will? Just a little tidbit to take away from everybody. So the Paralegal Minute is something that we just started last month, as you guys know, and it's kind of an insight into these crazy fact patterns that we get in our cases. Because not everything's like a slip and fall. Not everything is, a really drastic accident. Some of them are so mind-boggling that it actually would make sense for other people outside of our world to believe that we're doing the right thing. We're fighting the good fight, right? Have you guys ever told friends and family what you do and have them come back to say oh, you're representing the insurance companies or the employers?
Oh yeah, all the time.
All the time.
And
always the bad guys.
Right.
Yeah.
I think we're the worst people in the world. And these are the types of cases that make people think, oh, you know what, they're not so bad. Right? So last month we had Morgan Celentano and Emily Galena-Smolka talk about this guy that was a drug mule and that he was arrested, so he couldn't appear for his hearing and his benefits were suspended. Now, I know as loyal listeners of the show and friends of Morgan and Emily, you guys listened to at least that segment. What did you think about that? A claimant being a drug mule. Do you guys ever talk to them after that they found that out, or Morgan's case when it first occurred?
No, it was insane to hear that someone couldn't appear for another claim because they were arrested for something else.
Right. It's I can't appear because maybe I'm sick or I have COVID. That's your run of the mill things.
Excuses.
I was arrested for being a drug mule.
I actually think after that podcast we got into that whole spiral with if you're doing something illegal, how do you report to your employer you got injured?
Oh.
About if you were selling drugs and you got injured at work but you're technically doing something illegal, would you report it? Right.
A coworker of ours who shall remain nameless got into a car, I guess he went on vacation and he came back and his car got dinged up.
Yeah.
And we were thinking about how, well, what if the person was drunk, right? They're not going to call the cops and say, come to the scene now. But we realized he filed his own police report to let our coworker know that his car was hit. What a good Samaritan that person was. No one would have ever found that out. Have we veered enough off topic, though?
Yeah.
You had a case that wasn't a drug mule, but this guy's a little shady. So.
Oh yeah, 100%. There were some pretty sketchy things.
So what happened in your case? What starts us off here with the wheels turning?
Okay, So we have this one case where the guy, he's been treating with the same provider for like almost 15 years. And he gets injured, while he was moving like boxes of like kitten litter on a dolly. And all of a sudden,
tough job.
Yeah, absolutely. He was a doorman too. And all of a sudden, his treating doctors.
We also love doormen. That wasn't a comment on doormen.
Yeah, no, they're great. Shout out to them. But anyway, his treating doctor kept putting him at totally disabled, and all of a sudden, we come across this one interesting thing after this hearing where the treating doctor is like, oh yeah, he's allowed to play golf out of everything that,
So like was that the thing that alerted everybody? Like he's allowed to play golf?
Kind of. So so he had like a independent medical examination where like, even our IME found him at like totally disabled.
Oh.
Which was like crazy because, usually our IME, like unless it's like super serious, they don't have them as like totally disabled. Yeah. So we had the adjusters like get surveillance on him, and we found him doing like crazy things. And like we actually like have video surveillance of him like playing golf and like, driving around in his golf cart and like lifting clubs. And yeah, so we raised that.
So that was before the note.
That was before the note.
So like they got surveillance because of something else, right?
Yeah, they got surveillance because they were suspicious. They were like, oh, why is our IME like finding him at totally disabled? Like there should be something. It's just like a minor like low back injury.
So what's like, because a lot of our clients get surveillance and it doesn't turn up anything, right?
Yeah.
You just find them sitting at home or like walking the dog, nothing too crazy. What, like you mentioned him playing golf, like what exactly, like was there anything else? Like what did they have him doing at the golf course? Was it just like, they actually catch him playing? Or
they like had him like driving the cart and like bending down at his waist level, and like with someone with like a back injury, like that's kind of hard to do, and like especially, and then they also caught him like lifting the golf bags, and like I'm sure like most people are aware that like golf clubs like weigh like a lot.
They're pretty heavy, especially with the bag.
Yeah, especially for like an elderly gentleman. It's kind of he's in his 70s too, mind you. So yeah. So you would think that like, oh, well, maybe he would have some trouble with that. But no, he was perfectly fine.
Huh. So like, what do we do with it? Like, what happened next? Like,
okay, so then at the hearing, we raised fraud, to let the judge know that like, hey, like, we have surveillance on this guy and like we caught him doing all this. So then after that, the hearing, next hearing was scheduled. Literally a week and a half later, treating doctor files a medical note with the board saying that like, oh yeah, he's like, he can return to work at like in like a light duty position, and like he's allowed to like do like activities. Specifically he's allowed to play golf. Yeah,
such a random.
Yeah, I know. Like out of all the things that like he could do, like golf is like the one thing that playing golf is like the one thing that he specifies.
Do you guys think that like when the doctor says that, it's like almost like the claimant knows what we know at that point?
Oh yeah, the claimant had to have requested or something, mentioned, hey, I play golf, like let me play golf.
Yeah. That's the funny thing that happens, like like before virtual hearings, right? When we go in and raise fraud, claimants attorneys would take their claimant out of the room and say like, tell me what they have. What have you been doing, right? And here, I guess like that conversation happens over the phone or through emails that you don't actually see it happening, and I guess that manifested itself in the doctor saying, "Well, he could play golf."
Yeah.
Well, I think when we talked about this case, you mentioned a pretty sketchy part also at the deposition when Vandana asked him about the note specifically, and he said, "Oh, it was generated. It was like an
automated generated note." So yeah, he was like someone in my office.
Generated by who? The claimant?
Yeah, exactly. He had no idea.
So like, Okay, so Vandana Saunders, our attorney here, she asks a question on deposition of this doctor to ask about this like fortuitous note that allows him to play golf, like, and what's her intention? I guess she's trying to get him to admit that this was just some kind of fabrication, and he just like this is an auto-generated note. What does that even mean?
All he said was that, yeah, I'm not sure where I got this note from. It was just maybe someone in my office like wrote it and like filed it, or like, yeah, he basically like said that.
Like maybe the claimant's attorney?
Yeah. Like, I mean, his signature's on there. So
that's wild. Okay, so we have surveillance, like we caught you.
yeah.
Mm-hmm.
We file for fraud. The claimant freaks out, gets his doctor to file an amended note. And we have a fraud trial, I'm assuming, where he testifies?
Yeah, he did. And one of the crazy things that happened during his testimony is that he basically said that, oh yeah, I like play golf, and like, before like even like the hearing happened, like, the initial hearing where we like raised fraud happened, he was like, oh yeah, during like, the week of April, I was like playing golf like this many times a week, like I guess like he said like a few times during the week, and he played like 18 holes in like 3.5 hours. Like, do you think like is that a long time?
Well,
like especially for like
when we were talking about it, you were just like, that's pretty quick, right? You said it was too long. You said it was too long.
I don't
we thought it was too long.
So I was like 18 holes for 3.5 hours. Don't you just
it's like everyone that's not watching, Christian's just like, don't you just and then a swinging motion.
I'm like 10, 15 minutes, you're out of there.
Right, you're done.
18
you're
holes,
just done.
easy.
Like I've played mini golf before.
Exactly.
Well, like, so when you're thinking that it's short, does that make him more disabled or less disabled? Wouldn't that make
less?
Right?
Because he's like doing all these things. Even like during the treating doctor's testimony, he's like, yeah, he's a healthy, fit guy. Like, yeah.
It's like.
And go back to work.
And then he can go back to work and like play golf all of a sudden. Yeah.
Oh my God.
Then why are you saying 100%
exactly
disability if he's a healthy, fit guy all of a sudden?
It's like this guy can play golf twice a week, something I would love to be able to do. But, no, I'm here working. Right? You should be too. So, he testifies to playing golf for 3.5 hours. I guess, just an admission of my own golf failures. I have never been able to play 18 holes in 3.5 hours. So he must be a great golfer, which I would actually agree with you saying like, oh, well, you're less disabled.
You should ask him.
I mean, if he
teach you some tips and
I need some tips. A little fraud trap, like more. Just like, hi, I'm really bad at something that you're good at.
Yeah, please help.
So he testifies that he plays for 3.5 hours and
a couple times a week too.
A couple times.
So that's like what? If you say that it's like, if it takes you like 4.5 hours, like 4 hours to like play that many holes, like wouldn't that mean that like he's spending like, I don't know, what's 4 times 16?
64.
Yeah, like that many hours per week.
Yeah, 64. Like, wouldn't you also think that, like, he's thinking for him to say that means that he thinks that that's okay. Right?
Yeah.
Because, like, if you think that that's going to hurt you, you're going to be like, no, I don't play that much.
Yeah, but he also says, too, like, oh, but don't worry, don't unload my clubs from the car.
Yeah.
I don't unload my clubs.
He was like, I usually have someone help me with that. But you don't.
Who?
Like, that's the easy part. Isn't the easy part maybe getting the clubs out of the car?
Right.
Mm-hmm.
Right. So it's
not
like,
playing for 3.5 hours.
I mean, I see sometimes like old people when they like get it in the hole, like they have to bend down to like put their hands by their feet to grab the ball. Like that's like probably the hardest thing to do is someone who can't or who has problems bending. So like what happened? Did we win? I'm asking because I already know the answer.
No,
just trying to make it sound more seamless.
Unfortunately have to do an appeal because at the last hearing, like the most recent hearing, Vanden gave summations about like raising fraud and everything. We told them that like, hey, this dog, like the treating doctor. Oh, another interesting thing, treating doctor like dodged us like 4 times. So we had like 4 back-to-back hearings where like the treating doctor, we had to tell the judge that like, hey, treating doctor never appeared at our depot date, so can you give us an extension? And thankfully he did. But
so he finally showed up after like just being scared.
Yeah. And then he like basically admitted to everything. And then all of a sudden, the judge is just like, oh yeah, no, we can't raise fraud. There wasn't enough like misinterpretation. Like there wasn't enough, yeah.
At that point, it's like,
fraud.
what do you have to
There
do?
wasn't
Like,
enough
what
fraud there,
do you have to do to show that, like, you're just lying or being just, omitting something, like, from that, right? Like, what do you have to do to, like, get a fraud finding from this judge? Be like, so you're hanging out, playing a sport for 7 hours a week, not working, but your doctor says they can't work, and now miraculously says that you can after they raise fraud. What do you have to do at that point?
I don't know. You know what's another crazy thing? He also has a caregiver. So, like, he has a counsel at hand.
Did the caregiver come to golf with him?
I'm pretty sure he did. And, apparently at one of the hearings when he testified, so at one of the hearings, claimant's counsel, like, didn't appear. So
Wait,
the
what?
yeah. So then...
Can you imagine, like, the fear if one of our attorneys just missed a hearing?
Oh my god. I can't even.
What?
No. But
The caregiver took over.
the caregiver.
She's like, I got this.
Right.
Yeah.
I'll be your attorney.
Literally.
I don't even know why I made that voice. Like, I don't know what I was trying to prove there. Like,
I mean, if he's a caregiver, he's probably older than you, Christian.
okay.
So-
okay. I'll remember that for the next time I try
Yeah.
to impersonate.
Yeah, just
older
use your
person.
own voice.
Exactly. Yeah.
Oh, okay. All right. Just
So then
fine.
this caregiver, I'm just getting back to it, this caregiver, like, appeared on behalf of the council, saying all these things of, like, oh, yeah, claimant, like, does this, and, like, he's, like, playing and, like, engaging, and then all of a sudden the judge is like, yeah, no, you can't say anything on behalf of the claimant.
Wow. That's such a crazy thing. Also,
Yeah.
if you're the caregiver, you must really be invested in this
Yeah.
person,
Mhm.
right? Like, I'm going to
Testify
testify
for
for
Yeah,
you
literally.
Under oath and potentially commit perjury. Like, why? Just props to that caregiver.
Yeah.
Sometimes you just need someone in your life like that.
Yeah.
So we lost, and we're appealing, but ultimately, I think, like, that's
It's a pretty strong appeal. Like,
Yeah.
we have a lot of things
I
against
love,
this
I love
guy.
the confidence.
Yeah.
I love the confidence.
No, 100%.
Like, it's a strong case. I love it.
No, it's literally 4.5 pages of, like, facts. So
4.5 pages
the
of
judge that ends up reading this, you better approve it.
3.5
Yeah.
hours of golf.
Yeah, literally 3.5
One
hours.
page for every hour of golf
Exactly.
that you do.
Please.
Oh my lord. Just like the idea that you think that what we do is so bad, right? I mean, our adversaries, like, try to make your lives and my life like just trouble when we just try to do our job. And this is the stuff that we find that I think maybe, I don't want to say puts them in their place, but it gets to the point of saying, like, look, like, something's weird going here. I think when you can't go back to work after a certain amount of time, it's like, what are you doing, right?
Yeah.
No, that's very true.
Yeah. All right. Well, I hope this guy has, I guess a good summer. I hope he gets out there more, right? I guess if his doctor says he can play now, maybe he'll go out for like 14 hours, 20 hours a week.
I mean, pretty sure he's like probably
He's
collecting
released.
the retirement money.
No
Oh,
work
yeah.
but golf.
Yeah.
I've got the approval. I can't work.
Can't work, but I can
I can play golf.
Yeah.
And I'll just set up whoever this mystery person is that's going to lug bags out of my car.
Caregiver.
Yep.
Yeah.
Caregiver that's following him around.
Okay. Well, I'd like this case just because it demonstrates some of the interesting fact patterns that we get on a day-to-day basis. It's not every day you get this kind of case, but they happen. And for our clients, keep trying with covert surveillance. The weird thing is that claimants and claimants' attorneys, they know this stuff is happening, but they can't stop like a claimant from making this decision sometimes. So like, don't feel that you should not get it due to cost. Like, think about the big picture here. Any other takeaways that you guys have, other than?
Sometimes the claimants just go off the rails. We can't do much about it.
I was actually telling Pri about this case. We have a very similar one that's not, we didn't have a hearing yet for it, but our IME was finding him 75%. And then we got surveillance, and he was at Planet Fitness for 92 minutes.
Yeah, wasn't he,
92
lifting
minutes.
weights.
Lifting weights, doing sit-ups. He was actually running on the treadmill forward, sideways, and backwards.
Backwards?
And plates that were more than 25, right?
Yeah.
That's
it
the
was
kind of thing.
just-
It's like, I can't even do that. So,
Yeah.
and if I'm not
I
disabled.
literally can't even
Right.
do that.
Right.
For 92 minutes,
92
that's
minutes?
a long time to be at the gym.
Good investigator
Didn't,
there, too.
the IME
Yeah.
also
Jeez.
give him a lifting restriction or whatever?
I think he was telling the IME doctor, I can only lift 10 pounds. I can't do this. I can't do that. But
It's almost like we're planting the seeds for a
he
future
was
episode.
doing it.
I'm gonna have to it's a little bit on me. I gotta convince you guys to come back. Hopefully this turns out well, right? I think that this stuff is exactly what makes the engine run. So I want to thank you guys for coming on. Thank you also to Ian Haberstro and Addison O'Donnell for their segment regarding a recent appellate division case and how it affects our clients' permanency. So for Pre-Rana, Krista Karamanis, Ian Haberstro, Addison O'Donnell, this is Christian Cison reminding you to defend from day one.